Hello everyone, this is Professor Al Merriam, your instructor in Political Science 2030, and this is supplemental lecture number 2 on the California judiciary. In the first supplementary lecture, we covered the federal judiciary, and that has already been posted on Blackboard. In this supplementary lecture, we have 4 objectives. First is to conclude our coverage of California government. Unfortunately, we cannot cover other aspects of California government, so we have to concentrate on the 3 branches of state government. So we've covered those, and this is the last section of California government. I urge you to read the short PDF document I posted on Blackboard. I will give you additional information. Here we shall examine the California judicial process. We shall also try to compare and contrast the federal and California system, and then get into the nitty-gritty, the mechanics of the criminal and civil system in California. First, let's look at the role of the judiciary, and this role is not necessarily limited to the California judiciary. It is relevant to all the judicial branches, and that is to give everyone fair access to the courts to solve legal problems fairly and efficiently. That is also known as due process of law. In other words, we have an orderly system of laws and administration of those laws, and the function and purpose of the judiciary is to make sure that the laws are implemented in a manner that is fair to all parties coming before the court for resolution. In a criminal case, it is to determine guilt or not guilt, and occasionally innocence, but the criminal process is not about guilt or innocence, but it's about the ability of the government or the prosecution, whom they have charged with a crime, and their ability to present sufficient amount of evidence that meets the test of beyond a reasonable doubt. And so the role of the court, the role of the judges, is to ensure that guilt or the absence of guilt is conducted in a manner that is consistent with the constitutional provisions which protect the right of the individual, the accused. And of course, the third objective or role is to interpret the laws and protect the rights and liberties guaranteed by the constitutions of California and the United States. So in California, of course, both federal and state judicial processes take place, but we are focusing principally on the California judicial system. Now, California has 2 types of courts, much the same way as the federal courts, and that would be the trial courts, where trials take place. Evidence is presented. Usually a jury decides on the factual merits of the case, and then a decision is made or a judgment is rendered, and then it's taken to the next level of review, which is the appellate courts. Now, in California, the trial courts are called superior courts. You'll recall that the trial courts in the federal system are called district courts, U.S. district courts, and these are California superior courts. There are 58 trial courts, 1 in each county of the state. And in the California superior courts or trial courts, much of the same thing that happens in the federal district court also takes place. Usually you have a judge and a jury, depending upon the option the defendant takes, and that is the option of the defendant, to have a judge or jury trial. In most cases it's a jury trial. Then evidence is presented. That's part of what we call the trial, is to present evidence in court in the form of testimony, physical evidence, expert evidence, whatever kind of evidence that you have that is allowed by law, and to determine the factual issues. Of course, there will also be some questions of law that would arise. That would be the concern of the trial judge. So the distinction here is that the jury determines questions of fact. So if it's in a criminal case, it is up to the jury to determine whether the accused is guilty or not guilty, and that's all they do. They don't interpret the law. They don't apply it They are usually given direction by the judge on how to evaluate and assess the evidence. But any other questions of law, whether or not evidence is admissible, whether or not a question of law with respect to the admission of certain kinds of testimony should be allowed, or whether it's privileged, or any other kind of evidentiary issue related to what the jury will hear in deciding this case will be determined by the jury, and of course, ultimately, the judge will pass sentence. So the role of the judge is pretty much limited to presiding over the case and ensuring that neither side takes undue advantage of each other, and to make sure that the rules of evidence are followed, the rules of court are followed, and there will be a fair trial. In other words, the ultimate test is whether or not due process is followed. And so in the superior courts, all criminal cases, felonies, misdemeanors, and traffic tickets, we'll see that later in later slides, are adjudicated or determined. And also all civil cases. And civil cases involve the following: family law cases, probate cases, juvenile cases, personal injury cases, and other administrative kinds of cases as well. So the principal distinction you may want to make is that in a criminal case, especially if it's a felony or a misdemeanor, the principal consequence is that there's going to be deprivation of liberty, or the person may end up in jail. In civil cases, the ultimate penalty is either in the form of money damages, or in the form of some kind of relief, which would not involve jail time. So in a family law case, it may be adjudicating a divorce or child custody cases, or in a probate case, it may involve a distribution of estates and things of that sort. Then there's another category of courts called the small claims. Perhaps some of you may have experience in that. And these are claims that usually amount to $7,500 in contested damages, and could also go, under some circumstances, much higher than that. And also the trial courts, or the superior court, sit as an appeals court in misdemeanor cases. So, and in small claim cases, they also sit as what's called de novo. They hear the case also afresh, if they have to. The appellate courts, just like the federal appeals courts, are also of two levels. The first, the intermediate level, is the courts of appeal, and the highest court in the state is the California Supreme Court, just as the U.S. Supreme Court is the highest court in the United States. There are 6 courts of appeal and 1 California Supreme Court, and the courts of appeal, as in much the same way as the courts of appeal at the federal level, they also are intermediate courts of review, and they're as indicated and divided into 6 districts. We happen to be in the 4th district, Division 3. So as you can see here, 4th district includes San Diego, which is Division 1, and we are in Division 3. I think Orange County is in Division 2. So the basic function of the intermediate appellate course is to undertake review of the Superior Court judgments. Now, the appeals process is, again, similar to the federal process. People who are not satisfied with the trial court decision can appeal their cases to the appellate court. If it's a criminal case and the person is convicted, the person can seek review, appellate court review of that conviction, alleging oftentimes an error of law, some allegation that the person was denied due process in the trial court. For instance, evidence was admitted that should not have been admitted, or the person was denied a particular right. such as, for instance, a person was denied effective assistance of counsel. Or there was a problem with the jury in the way they made a determination. They considered some evidence that they should not have. So whatever the reasons may be, usually it's an error of law because there is no factual review at the appeals process, only questions of law. And the appeal is basically to ask for review and to determine if some error of law took place. And so in that regard, the courts of appeal do not sit as trial courts, which means that they do not seek additional evidence. There will be no testimony, no witnesses, and things of that sort. So the review is based strictly on the record, the court files and the transcripts, and the transcripts include the written transactions of everything that happened in the courtroom, all of the questions asked by the lawyers, any questions asked by the judge, any rulings made by the judge, all of that stuff is included in the trial transcript. You have a court reporter sitting there and taking down all of the questions and statements that are made inside the courtroom, and that would be the basis for the court to review, along with any other documents, motions and such that were filed during the trial. And so that would be the only basis for the court to review. The appeals court rarely asks for additional evidence, although in criminal cases, if one files something called a habeas corpus petition, which is separate from an appeal, additional evidence could be added, but that would be a separate kind of process. And in the jurisdiction of the California Court of Appeals, to deal with habeas corpus is original, meaning that it doesn't have to be filed in the trial court and then appealed. It could be filed directly in the appeals court. Now, in the appeals process, the way things work is that the parties will file a brief. That would be a statement, be a legal document known as a brief, wherein they set their legal arguments and their legal positions. So if they allege that some legal error occurred, then they will identify that issue and then provide a citation to the record, to the transcripts, showing how the judge ruled or what evidence was inappropriately admitted or whatever it may be. They make their statements in this document called a brief. And both parties will submit a brief. Usually the petitioner, the one seeking a review in the appellate court, files the opening brief, and then the government, oftentimes in a criminal case, files the reply brief or the respondent's brief, depending upon how it's characterized. And once that is filed, there may be additional exchanges. There may be a reply to the reply. So once the briefing process is completed, then the matter is scheduled for what is called oral arguments. A date is established, and then the lawyers will go to the Court of Appeals and argue their cases. Basically, they will restate some of the arguments, or hopefully they'll come up with some new issues or new arguments which shed light on what has been written, because the main argument has already been stated in the brief. So new arguments, entirely new arguments, would not be very helpful because they're not part of the brief. But the principal reason for oral argument is for the lawyers to appear before the court and answer some questions, because they may have written things in the brief which may not be clear, or the judges may have questions of their own, and they want to get clarification from the lawyers. There are no juries or witnesses, only the lawyers will go in, and usually they're given a set amount of time, about 20 minutes to 30 minutes, to argue their side. That includes questioning by both sides, and they can reserve some time if they would like to offer rebuttal arguments. So they may save some of their time and then respond to each other's arguments in case they need to do that. The California Court of Appeal judges also, just like the federal judges, sit in panels of 3 called justices, and they decide the appeals that flow to them from the superior courts. Now, the courts of appeal can agree with the decision of the trial court, in which case they affirm. The judgment of the trial court, or they may agree in part and may disagree in part, and in their opinion they can indicate that. Or they can disagree entirely and reverse the trial judge's decision. So in a criminal case, that means the accused gets a new trial because something fundamentally went wrong in the trial, and as a result, the only way to make it right is to give the person a new trial, and that's what a reversal of a judgment means. But in the vast majority of cases, the judgment of the trial court is upheld, and if changes are made, it's usually modified in some respect, sometimes minor, sometimes major, but it doesn't undermine the judgment of the trial court to a point where it will have to be reversed. Oftentimes you'll have sentencing errors, those could be corrected. But on balance, the vast majority of those trial court judgments are upheld. And then oftentimes the Court of Appeal will issue its decisions, and those decisions are called opinions. And if the court allows it to be made public, then it is published and made available online. But the vast majority of decisions of the California Court of Appeals, unlike the federal system, are not public opinion, so they're not published. And the distinction, of course, is that if they're published, then they become part of the body of law called precedent, and they can be relied upon in the future, in future cases as precedents. But because many of these cases do not really involve major questions of law or novel questions of law, they just decided on the merits and left at that, and so they cannot be cited as authoritative precedent for future cases. Again, the structure here for the appellate courts, and where what the distribution looks like geographically. Here's sort of geographic representation of the appellate court distribution, and they're color coded. As you can see, the first appellate district covers northern California, beginning further north of the state along the coastline, and as you can see, also the fourth appellate district, where we are in, is in yellow. So this kind of gives you a distribution of how the appellate courts are distributed throughout the state. Let's do a quick comparison between state courts and the federal courts. Again, the California Supreme Court is the highest court in the state of California, as is the United States Supreme Court for the United States. The Courts of Appeal, with the various districts, 6 districts, are the intermediate courts of appeal. And in the federal system, we belong to the Ninth Circuit Court of Appeals. And so you should remember that. And of course, at the triad level, each of the 58 counties have their superior courts, and the United States District Court, as I said, have 4 districts in California. And so you can get a sense of the distribution there. Of course, the vast majority of civil and criminal cases, as I indicated in supplemental lecture number 1, take place in state courts, and that's why you'd find over 95% perhaps of criminal and civil cases being prosecuted. This is just a picture of the United States Supreme Court. United States Supreme Court does not allow pictures or video to be taken while the court is hearing oral arguments, but the recordings of oral arguments are made available immediately after a case has been argued, and they're available online. Can be easily searched and found. California Supreme Court, as you can see, is a picture. I believe this one is in Sacramento, where I once argued a case back in 1997. It's very similar, perhaps even more ornate than the United States Supreme Court, but it's you have 7 justices, and as you can see, the lawyer here is they're having oral arguments, and the lawyer is presenting his case. Now let's look at the California Supreme Court and some of its activities there. As I said, it is the highest state in the court, and what that means is that all other courts, the courts of appeal, superior courts, and so on, are below the Supreme Court, and they have to abide by the decisions and the precedents of the state's highest court. So, in the hierarchy of judicial authority, the state Supreme Court sets the highest standards, and the lower courts must follow that. And because of certain kinds of technical requirements, the California Supreme Court, if it so chooses, can review cases decided by the courts of appeal. But review in the California Supreme Court is not as of right, which means that because you've been convicted in a criminal case, you have the right to appeal in the Court of Appeal. But beyond that, the criminal defendant does not have the right to appeal directly to the California Supreme Court, because the California Supreme Court, just like the United States Supreme Court, selectively takes the case that it wants, and it has its own rules and standards. In the federal Supreme Court, we have a petition for certiorari. So if you want the case to be heard in the U.S. Supreme Court, that's what you'd file. You petition for certiorari. You basically ask the court to review your case for you. In the same way, in the California Supreme Court, you file what's known as a petition for review. You ask the California Supreme Court to review your case. And that's discretionary. Sometimes they will review it, sometimes they will not, and the chances are very slim that they will be reviewed, just like the U.S. Supreme Court. Now, there are certain kinds of cases that go directly to the California Supreme Court on appeal without being heard first by the courts of appeal. And these are basically death penalty appeals and disciplinary cases involving judges or lawyers. So nearly every other kind of appeal must either go through the Court of Appeals and terminate there, or be granted review once the person files a criminal or civil petition for the California Supreme Court to consider the case. The court conducts regular sessions in San Francisco, Los Angeles, and Sacramento, and sometimes they hold special sessions in other cities, but these are the 3 places. So if you ever want to watch oral arguments or see how the California Supreme Court does its business when it comes to Los Angeles, just call or check online. You can go and attend. There is no requirement. Anyone can attend oral arguments. There are 7 justices on the California Supreme Court, and a majority of at least 4 must agree on a final decision. And as you recall, the U.S. Supreme Court has 9 justices, and you need at least 5 to issue a final decision. And all other state courts must follow a decision made in the Supreme Court, meaning that Supreme Court precedent, state Supreme Court precedent, as well as Supreme Court President of the United States, are supreme, and therefore must be followed by the lower courts, whether they like it or not. It's mandatory. The justices, California Supreme Court judges are called justices, are appointed by the governor, and then confirmed by the voters at the next general election. They serve a term of 12 years, and every 12 years they must be confirmed again. One additional requirement is that they must be lawyers. There is no federal constitutional requirement for qualification that federal judges necessarily be lawyers, but because of the requirements, all Supreme Court judges are lawyers, or federal court judges are lawyers, or have been lawyers at some point in their careers. Now, the California Superior Court, the trial court, this is a picture of what the trial court looks like. As you can see, you have the bench at the top where the judge sits, and to the left of that is where the jury box is, and then the court clerks and so on in the foreground to the right. Pretty simple and straightforward. Now this picture shows a more detailed distribution of who sits where and that sort of thing. In the trial court, as you can see, the judge sits in the background there, and the chambers are his private offices in the back. That's the door that you see there. And the courtroom clerk sits to the left with the court reporter on the right. The court reporter is the person who sits using a typewriter-looking machine and recording all of the transactions taking place in the court. Any statements made by the judge, by the lawyers, and any other observations and statements made by witnesses and so forth. And then you have the jury box, and where in the foreground where you have the table for counsel. And of course the court officer, the bailiff, sits to the left, making sure that nothing untoward takes place in the courtroom. Judicial appointments, judges are appointed by the governor, then confirmed by the voters, as I said, for a period of 12 years, and then they must be confirmed again. What is important here, of course, is that in comparison to federal judges who are appointed for life term, state judges, at least at the appellate level, Court of Appeals and the Supreme Court, must be reconfirmed by the voters every 12 years. Now, judges do not run as Republicans or Democrats or on a party platform for obvious reasons. They do not administer justice based on party affiliation. They administer justice with loyalty to the Constitution and the laws, and therefore they are presented to the voters without any indication of their political views or how they would rule on cases and things of that sort. Now, to be eligible for appointment as potential judges, of course, they must have passed the California bar exam, and they must have served a judge of a court of record in California at least 10 years before the appointment. So there's a much higher level of, much higher standard of fitness for the state judiciary. Now let's look at the criminal and civil process. The state level will look at those in subsequent slides, but generally in civil cases, anybody can start a civil case. It could be an individual, a corporation, or a governmental entity. And in the vast majority of cases, they're seeking some kind of money damages, or they want some kind of change in behavior. What that means very simply is that the court will issue some kind of a restraining order or an injunction. They're not going to give them any money, but they will stop some conduct that they do not wish to have continue. So it could be a restraining order in a domestic case where the person seeking the restraining order does not want the other party to come near them because they fear for their safety. In civil cases, there is no Fifth Amendment privilege because the Fifth Amendment applies only to criminal cases. There's also no right to a free lawyer. If you start a civil case, you have to provide your own lawyer or represent yourself. And the standard of evidence in a civil case is what's called preponderance of the evidence. Compared to a criminal case, preponderance simply means, roughly speaking, the jury believes your side of the evidence 51%, versus 49% for the other one. It's the lowest level of evidentiary standard. It's basically whether they believe one side or the other. Now, in a criminal case, you should keep in mind that the criminal case can only be initiated by a governmental entity. So for federal cases, as we've seen, it's the U.S. Attorney's Office, and in a state case, it could be the local district attorney or the state's attorney general's office that can bring a criminal action. And usually that's the criminal action is brought to punish a person for having violated the criminal laws or to rehabilitate them. But in a criminal case, the right of the accused, as we've seen in Chapter 4, the accused has all kinds of due process rights: the right to remain silent, the right to legal counsel, the right to an impartial jury, and all of those 4th, 5th, 6th, and 8th Amendment rights attach in a criminal case. There is no such protection in a civil case. So the bottom line in a criminal case is proof beyond a reasonable doubt. And as we said, in a civil case, it's preponderance of the evidence. Which one weighs a bit more than the other. In a criminal case, is a much, much higher standard beyond a reasonable doubt. Doesn't mean that the defendant probably did it. More likely than not, he did it. I think he did it. More looks like he did it, and so on. So the whole idea, beyond a reasonable doubt, means if the juror, the fact finder, has a single doubt based on reason, then they must acquit the defendant. So if there is a whole bunch of evidence against the defendant, but there is one very important piece of evidence over which the jury has doubt about, then they have to find the defendant not guilty. So that's the standard of evidence we call beyond a reasonable doubt. It's a very, very high standard, and it is up to the prosecution to prove that case. The defendant doesn't have to do anything because under the Due Process Clause of the 14th and 15th Amendment, the defendant doesn't have to prove his or her innocence. In a criminal case, it is up to the government to show or to prove that they have committed the crime. Now, the Judicial Council of California is the administrative body that administers the California court system. And the Judicial Council does a whole bunch of things. It plans and adopts policies and rules that govern how the courts of appeal, the superior courts, must work. They conduct studies, they establish policies. They do a whole bunch of things to make the course fair and efficient. The council has 27 members, and that includes the Chief Justice of the State Supreme Court, and 14 justices appointed by the Chief Justice, as you see there. 4 attorney members appointed by the State Bar Board of Governors, 1 member from each house of the legislature, and 6 advisory members. And the Chief Justice chairs the Judicial Council. Again, the aim of the Judicial Council is to ensure consistent, independent, fair, and accessible administration of justice in the state. Now let's look at your rights and responsibilities in court, kind of the mechanics. In California, both the state and, of course, the national constitution guarantee certain kinds of rights to the individual. And these are constitutional rights, which means they cannot be taken away by the legislature or disregarded by the courts. And so part of this constitutional right to access the courts and to vindicate one's rights include the right to sue for money owed or for other forms of compensation or help in civil cases. An individual has a right to defend oneself against a lawsuit, whether it's a criminal or civil case. An individual in a criminal case is considered innocent until proven guilty. So when the criminal defendant sits in the courtroom during trial, that person is presumed to be innocent, and it's up to the prosecutor to prove that person is guilty by showing sufficient evidence of guilt. And then the right to defend oneself against criminal charges, and of course all of the other rights that are attach as a result of the Bill of Rights or under the state constitution. And so those are the obligations of the state. Now your obligations in legal cases, you're responsible for finding a lawyer who can help you with your case. In a criminal case, you don't have to worry about that. If you're poor, the court will appoint a lawyer for you. That is if you do not have the means to hire a lawyer. But if you do have the means to hire a lawyer, then you have to pay for your own lawyer. Now, it is possible to represent yourself, which means that they have to do all the legal research, prepare your documents, file and serve your documents, present evidence, and follow all the laws and court rules as if you were a lawyer just as well. That is not advised, but there are some individuals who do that from time to time. Of course, the court must treat all parties before it equally and impartially. And the judge, the court personnel, or any other person or agency cannot help you in court, whether it's in a traffic case or any other case, because they cannot take sides. Now, how does the case move in the California system? Here's a sort of thumbnail, a sketch. In civil cases that are not about breaking the law, there are all kinds of civil cases that include contracts, damages to property, or someone getting hurt, personal injury cases. There are also other kinds of civil cases, family cases involving divorces and child support and custody cases. There are also juvenile cases which involve the rights of underage persons, particularly minors who commit crimes. They're not taken to the adult course simply because the law is designed not to punish juvenile offenders but to rehabilitate them, and so the juvenile court has a separate process to deal with that. Along with landlord and tenant cases, those are also civil cases dealing with issues about renting or leasing an apartment or an office or some other premises. And in unlawful detainer cases, the question is whether or not the tenant can stay on the property. There are also small claims cases which involve disputes up to $7,500. So if you have a case that maxes out at around $7,500, you can go and argue your case or present your case in small claims. You cannot have a lawyer in small claims. Only you yourself can represent yourself. Another set of civil cases are probate cases. These are cases involving wills or trusts or transfer of property after someone dies. And also guardianships and conservatorships for people who cannot take care of themselves or handle their own finances. Those are also civil cases that go through the state civil process. And things like adoptions and name changes are part of the civil process. Now, how does a civil case work its way through the process? In much the same way as the federal case that we looked at, in state civil case at the Superior Court level, case could be limited or unlimited jurisdiction. That's very important. Limited meaning that the case is worth less than $25,000, or it's unlimited, it's above $25,000 in dispute. Of course, as I indicated earlier, in criminal cases, felonies and misdemeanors are dealt with in the Superior Court. But in much the same way as we've seen in the federal case, there's the pre-filing stage, the filing stage, the discovery, the pre-trial, trial, and post-trial phase in a civil case. Now, the pre-filing is basically when someone gets hurt or suffers some kind of legal damage, whether it's a breach of contract or could be in a probate case when the person dies and the property needs to be distributed to the heirs. So that's the pre-filing stages when you'd have to do a lot of things to get ready to file your lawsuit. You have to investigate the case, gather evidence, develop your theory of the case, prepare the complaint, those kinds of things. Once that has been done, the lawsuit will be filed. That's when you file your papers to start the court action. Usually, if you're the plaintiff, you file the complaint, and once the complaint is filed, the person in a civil case, the person who's alleged to have committed the wrong is served with the complaint, and the person will have 30 days to answer the complaint, or if they don't answer, they default, meaning that they in effect accept the allegation as true, and the court will proceed separately on a default judgment along that line. But once that has been filed, you have 30 days for the answer to be filed, and after 30 days, discovery starts. Discovery is the heart of a civil case, which means that the accusing or the plaintiff and the defendant have to exchange information, evidence that they have from each other. Subject to certain kinds of technical limitations, the plaintiff and the defendant must exchange relevant information and evidence with respect to the claims that are made, and that provides the basis for the evidence that's going to be presented to the jury at trial. So, through the discovery process, through the exchange of information and data, both sides are informed about the strengths and weaknesses of their cases, and they can now begin to think of the settlement negotiations and so forth. And oftentimes, after discovery is completed, the parties will seriously look at their positions and try to settle the matter without a trial. And in 95% plus cases, cases are settled out of court. Now, pre-trial starts usually about 90 days before trial, and that is after ascertaining that the case cannot be settled out of court. And during the pre-trial, there will be motions and other papers filed and hearings conducted, and so a time is set for the trial, and that would be the time when each party will have to make critical decisions on how to proceed with the trial, identify its witnesses, exchange witness lists. Oftentimes there will be a settlement conference with the judge in much the same way as in federal courts, and then if none of these efforts work, then the trial is conducted. And the trial can last from 1 day to many months, depending upon the complexity of the case. And once that is complete, a judgment is rendered, and that judgment can be appealed, or in a civil case, the judgment, if the plaintiff prevails, the plaintiff can collect on the judgment. And if the plaintiff loses, the plaintiff could also appeal, and the appellate process takes place thereafter. So this is a chart of how a civil case is processed in California court. You can see at the top, a complaint or petition is filed in Superior Court, and then it's served on the defendant, and the defendant files a response. And then immediately after that, discovery begins. And at all of those stages, one of two things can happen. If discovery shows that there is insufficient evidence, then the defendant can move for what's called a summary judgment, basically alleging that even what the plaintiff says is true, there is not enough evidence to prove that the defendant is liable, and if there are technical standards associated with that, but if that standard is met, then the matter may be dismissed, or it might go into settlement, and those failing, then it goes to trial before a judge or jury, and then a judgment is entered. So it's pretty straightforward process. Now in criminal cases, the process is slightly different. Criminal cases are filed, of course, if the state thinks that the individual has committed a crime, and it's usually at the local level. It's the district attorney who will file the complaint, sometimes referred to as information, or oftentimes referred to as an information. There may also be an indictment, but that's very rare. In the vast majority of cases, an information is filed by the district attorney to charge the person with the offenses. Keep in mind, only the state can charge a person with a criminal violation, not another person, not individuals or private agencies. Only the designated agency, either the Attorney General of the state or the district attorney. There are three types of criminal cases: an infraction, a misdemeanor, and a felony. An infraction could be a minor violation. Oftentimes, most traffic violations can be considered infractions. Usually there's a fine, very unlikely that there will be any kind of jail time. If jail time of any kind is involved, it usually would be elevated to a misdemeanor. And a misdemeanor is basically defined as a crime that can be punished by up to 1 year in county jail. Up to 1 year in county jail. And the most serious kind of crime is called a felony, and that would be robberies, murders, assaults, a whole bunch of other violent and property crimes. And if a person is found guilty of violating those crimes, that person can expect to do state prison time of over 1 year. So the distinction between felony and misdemeanor simply would be whether the person is going to do county jail time or state prison time. And of course, in felony cases, the person could receive the death penalty as well, not just simply prison time. And here's the process in a criminal case. As you can see, it varies depending upon whether it's a misdemeanor or a felony. If it's a misdemeanor, if a misdemeanor information is filed, that's the charging document. A warrant may be issued for the defendant to appear in court, and then an arraignment will take place. And the equivalent of discovery in a criminal case is the requirement that the government must share all evidence that it has collected on the defendant. So the burden is on the state to provide that information to the defendant, because they have the burden of proving that the defendant committed the crime. Since the defendant is presumed to be innocent until proven guilty, the defendant doesn't have any obligations to provide information to convict himself or herself. And then the matter could oftentimes end up in a guilty plea. If not, it could go to trial, and final judgment is made. And from that judgment, of course, notice of appeal can take place. So a similar process will take place also in a felony case. So a warrant could be issued for the defendant. Oftentimes a preliminary hearing is held. In a misdemeanor case, there is no preliminary hearing, but in a preliminary hearing, the judge will determine if there is sufficient evidence to bind over the defendant for a full trial. And if there is sufficient evidence presented at the preliminary hearing, then the process will continue to a discovery process, and then oftentimes a plea attempt is made to plea bargain, and if that doesn't work, a trial will take place and a finding of guilty or not guilty, and then an appeal can be taken from there. In terms of appeals, both criminal and civil cases can be appealed. Plaintiffs or defendants can appeal Supreme Court's judgment to the Court of Appeal. And the appellate court, again, will review for legal errors, and if it finds an error, it will reverse the decision if the error is prejudicial enough, so serious enough, or it can send it back to the trial court for other kinds of action to make corrections or to to follow certain kinds of instructions that the appeals court may have. The key thing is that both in civil and criminal cases, the vast majority of appealed judgments are not reversed but are upheld. Again, here's a chart on how an appeals process, how appeals are processed, both in civil and criminal cases. Very similar here. The first thing in the filing of an appeal is what's called the filing of a notice of appeal. So in a civil case, in a criminal case, the person seeking to appeal must file a piece of paper, a legal document called a notice of appeal with the Court of Appeal, and those are have a time limitation. And if that notice is not filed, then the appeal is forfeited. That's jurisdictional, which means that if you never let the appeals court know that you're going to file, and suddenly after the time has passed you appeal, it's not going to work. But once the notice of appeal is filed, usually instructions are given by the Court of Appeal to file briefs. Briefing schedule is made, and the briefing schedule will inform the lawyers what they need to do in terms of what date to file the briefs and so forth. And once the briefs are filed and the reply briefs and all of that has been concluded, then the court will hold oral arguments, and the parties could submit on the briefs, or they can appear and argue. That's up to them. And then the Court of Appeal will render a decision, and that decision could affirm, reverse, remand, or dismiss the appeal. And then from the Court of Appeal's decision, the party who is dissatisfied can request review with the state Supreme Court, and oftentimes that review will be denied. The vast majority of cases will be denied, but if the review is granted, then you go through the same process again. Briefs will be filed, and the trial court record filed with the Court of Appeal will then be forwarded to the California Supreme Court. Again, they will hold oral arguments, and then the Supreme Court, the California Supreme Court will issue its final judgment. And if there are additional issues that need to be resolved, then the party that is not satisfied with that can take the matter into the federal court system. With that, we conclude the California judicial process. Thank you for watching. It's a pleasure having you, and until next week, stay well.